So what happens here? Of course, we've been watching this closely along with other cases that are in front of the Illinois Supreme Court. But today's the day that the no cash bail law is going to be heard. A law that was supposed to go into effect January 1st, but you had dozens of state's attorneys across the state last fall sue, progress that case through. A Kankakee County judge on a consolidated case found it was unconstitutional on several grounds. And then the Illinois Supreme Court came in and said, we got to suspend this so there's no chaos statewide. They did that New Year's Eve, the day before it was to go into effect. And since then, it's been suspended. Now it gets its day in court. To talk about that and whether or not we should end cash bail is Jeff Clayton. He is the executive director of the American Bail Coalition. Jeff, thanks for taking time with us this morning. I guess just give us the rundown of what's going on here and your thoughts of should Illinois end cash bail. Good morning. Oh, I'm sorry, Jeff. Jeff, I apologize. Start over. I had the wrong pot turned up. Go right ahead.
Sure. Well, when I first saw this, I thought there's no way that Illinois can eliminate cash bail because they need to change their constitution to be able to do it. Illinois is a right to bail state, right to bail by sufficient sureties. So was New Jersey until they changed their constitution when the legislative attorneys determined that they had to change their constitution to eliminate money bail. Now, is it going to create chaos? Absolutely it is, because in New Jersey, they replaced it with a robust preventative detention provision where prosecutors file for detention in 47% of all cases. That's never going to happen in Illinois. The preventative detention is severely limited by the Constitution. So even if the legislature could get rid of bail, prosecutors are going to have no option to keep people in jail pending trial, except for a very limited amount of cases.
So let me get your response, though, to the supporters of ending cash bail. They say that they don't want poor people to languish pending trial. I mean, they're innocent until proven guilty, and they shouldn't have to wait in jail because they can't afford bail, while people who are of means and rich can't afford to bail out. What's your response to that?
Well, the judges smooth that out, and they set bails higher for people that have money than people that don't. The reality is that people who stay in jail, in general, have as many as 10 or 12 strikes against them, even on some of these small bails. And what I mean by that is they fail to appear in court or they have a lengthy criminal record of doing it in the past. And those are the people that get ensnared in jail. Our first-timers who can't afford bail stuck in jail? Generally not. And I think Illinois being a progressive state, we've already seen that those people just don't exist. And that's exactly what we saw in New York. Laws like this benefit recidivist defendants, period.
When it comes to the local impact of ending cash bail, how do you foresee sheriffs being able to manage their jails? Will this impact their bottom line?
Well, I don't think there's going to be much jail population to manage. I mean, I think it's going to be turnstile justice. In terms of the communities themselves, what we saw in New York is that the disenfranchised minority communities bore the brunt of the increase in pretrial crime as a result of all the releases that are going to occur. Same thing's going to happen in Illinois.
Jeff Clayton with us. He is the executive director of the American Bail Coalition. So we, of course, have those oral arguments set to begin here in about 15 minutes or so. From what you've seen reported on this particular case, how likely do you think that the plaintiffs are going to succeed here and have this overturned? Or do you think that the Illinois Supreme Court's going to side with the governor and the attorney general and the House Speaker and the Senate president who all support ending cash bail?
Well, the Washington Supreme Court in 2004 predicted that if this ever issue came before the Illinois Supreme Court, they would hold that Illinois is a right to bail state, which means that there's no possible interpretation other than a tenuous one that Illinois is not a right to bail state. You want to get rid of money bail, go change the Constitution like you're supposed to. That's what I think the Illinois Supreme Court is going to have to hold, and I just don't see really any way around that other than an extremely bizarre interpretation of what the vast majority of other state Supreme Courts have said. Yes, that means money bail. You have to offer a right to bail, period. And I think that's what the Illinois Supreme Court is going to hold.
Jeff Clayton, if the state does move forward with such an idea, would you support changing the state constitution if that was a move that had to be made by the supporters of ending cash bail if this was struck down by the state Supreme Court?
I don't. I think the right to bail sets a better balance. But let's just say that we did want to go down that road. What you would be looking for is setting an appropriate detention net and saying these are the charges and these are the circumstances where a prosecutor can file for detention. What we've learned over the years in systems that have done this, New Jersey being one, the federal system being another one is that it creates a culture of detention over time. And so at the end of the day, we say we can resist detaining defendants, but when we give prosecutors the power to do it, over time they use it more. So I think what history has shown is that the right to bail, existing in Illinois since, territorial days, it just sets a better balance in terms of, detention and release and the rights of the people and the defendants in these cases.
And does bail always mean money? Does surety always mean money?
No, sufficient sureties could mean a release on non-recognizance and a promise to appear. That could be sufficient in any number of cases. In fact, the vast majority of felonies, I think it's only about 45% of felonies in the United States have to post bail to be released, right? So most people are released on their own recognizance. Numbers are even higher for misdemeanor cases. So it doesn't mean money. It just means sufficient sureties, which could mean a thing of value, somebody else vouching for you, non-monetary conditions, house arrest. All these sorts of things are in the basket of things for judges to consider right now.
Jeff, any final takeaways here as we prepare for just a little over 10 minutes for the Supreme Court to open up and possibly take this right on up?
Yeah, no, it'll just be interesting to hear whether there's some dialogue between the Attorney General and the court on this issue of what does sufficient sureties mean, and I think there probably will be.
Great. All right, well, Jeff Clayton, American Bail Coalition, greatly appreciate your time this morning. We'll be watching. I'm sure you will be too, and let's connect again soon in the near future, okay?
Absolutely. I'm going to get the oral argument fired up now.
All right, it's Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk.